all right. That happened to me yesterday.
As you all are aware, we do normally take the consent agenda first. Are there items that the council would like to pull?
C3.
C3, okay. And I would like, oh, sorry about that. I would like C6. Now, as far as the, just so we don't miss anything, as far as the consent items for demolition hearing, I'd like to check and make sure if there are any people here to speak to these specific items. First, let me say that C1F has been brought into compliance and therefore is no longer on the list. 805 Moravia Street. Is there anyone here? 929 Oriole Street. 1536 Pleasant Street. Yes, you want to speak to that? Very well. Okay. 2715 North Patterson. Okay. 4089 Ogburn Avenue. Okay. All righty. And on C2, there are 3 items. 608 East 27th. Nope. 5015 Old Rural Hall Road. Okay. 1412 East 25th. Okay, all right. Since there are no people here to speak to those, and besides the 2 items that we would like to pull for the committee, do I have a motion on?
Move for approval.
Second.
All in favor?
Aye.
Thank you. Okay, let's take a look at C1C, 1536 Pleasant Street.
Ordinance ordering the demolition and removal of a structure pursuant to Chapter 10, Article 5, Section 10-203F1 of the Code of the City of Winston-Salem, with repairs less than 50% of the value of the structure, less than 6 months.
Okay.
Property located at 1536 Pleasant Street. Owner Emmanuel Reyes, Jamie Antonio.
Thank you. Ms. Stimson?
Good afternoon.
Good
afternoon.
My name is Stephanie Stimson, and I am the acting Code Enforcement Senior Project Supervisor in Mr. Bruce Bayless' absence. The property at 1536 Pleasant Street was cited for unfit housing violations. A hearing was held on July 9, 2013. An order was issued on November 25, 2013. The property remained vacant for a 6-month period after the expiration of the order and became eligible for demolition on July 1st of 2014. The fair market value of the structure is $7,383, and the estimated cost to repair is $3,586, meaning it's less than 50% of the present value of the dwelling. Therefore, based on this information, we recommend that an ordinance be adopted to cause this dwelling to be repaired or demolished and removed in 90 days.
Thank you. And we have someone who'd like to come forward and speak to this. If you'll come up here and give your name and address, please.
You need the address for the property or my
Yours.
my address, 1380 Heritage Point Drive. As you see, I'm not neither of the 2 owners of the property. I'm the Emmanuel Reyes' sister. He's out of town. I've been trying to reach the person that sent the letter, well, the person that's signed the letter, and I have not been able to contact any of them. I've been trying, and I haven't been able to contact any of the persons in that department. I'm here to ask for more time to be able to repair, because this letter just got to my hands after June 27, the date that I was asked to provide any proof or to be able to disregard this. I have a copy of the listing. The house is for sale. It's on a list. We're just waiting for a potential buyer to buy it. But if we're not, we need at least a few months to be able to see if we are able to, Mr. Reyes can sell the property, or if he has to remodel it or repair it, to be granted at least 2 to 3 months to comply.
Okay. Are there any, tell us your name, please.
My name is Jonico Reyes.
Reyes. Okay. Yes, ma'am.
Yes, thank you, Chair. The order is for 90 days. That means you got 3 months to repair.
Okay.
And if the selling of the house, if anyone buys the house in the appearance and the condition that it's in now, I would be I don't think that would happen. But you got 3 months.
Okay.
And
I didn't know that.
Yeah, you got 3 months.
Okay.
But when it comes back and there's nothing that's been done and it has not been cleared through our department, Mr. Brooks and his staff, then we'll be voting on this.
Okay. So basically, what he has is 3 months to comply to the list that's on the back of the letter. This list.
Yes.
Or sell it. Okay. Or no.
And that's either repair or demolish the house.
Yeah.
Okay. So he has 3 months.
Yes.
Okay.
And just for clarification purposes, it will be going to City Council for a vote on Monday night. So
Absolutely.
basically, they'll have 90 days from that point
Yeah.
to make the repairs.
From Monday night.
Yes.
Okay.
Assuming it's approved by City Council.
Do I need to provide with this, which is the listing? No?
I mean, it's
Yep.
up to council in terms of whether or not they want it.
Yeah, I wouldn't think that would be
Okay.
necessary.
Thank you.
Excuse me. I think it's important for her to know that selling the property will not stop the action.
No.
There's what's called a lis pendens that's filed, where the action goes against the property. So if the new property owner does their due diligence, they would see that there's an encumbrance against the property. But if you sell it, the new owner is still under the same requirements.
In the same 90 days?
Yes.
Okay, so basically the only thing that will make this go away is for the property to be repaired or remodeled?
Absolutely.
Okay.
Thank you.
Understood. Thank you.
All in favor of this action?
Aye.
Thank you. Okay, and now we have C3. Ms. Adams, wasn't it? Go ahead.
Consideration of an ordinance amending chapters 2, 10, 22, 34, 38, 42, 46, 50, and 74 of the City Code as they pertain to technical corrections.
Thank you.
Ms. Carmen?
Attorney Carmen, could you give us a brief description of which ones we're talking about here?
You have, just for information today, it'll come back in August, a draft code amendment that will amend various chapters within the city code, including Chapter 2, which would basically, the amendment would allow the manager to do change orders not to exceed $100,000 for the life of a contract. With respect to Chapter 10, it's just deleting references to Neighborhood Services Department to correct that to the current name of the department, which is Community and Business Development. Few of the amendments relate to correcting a few typos. And with respect to Chapter 34, as you know, with respect to privilege licenses, now in terms of this current fiscal year, we can only assess the privilege license based upon the fact that business is physically located within the city limits. So I had to change that code provision based upon the changes in the state law. Again, Chapter 38, changing the name of the Neighborhood Services Department to Community and Business Development Department just a few typos there. Clarify some language with respect to Section 3834 as it relates to activities of panhandlers, and mainly to prohibit their darting in between traffic to collect money and so forth, to deal with some safety issues there that have occurred since the amendments to the ordinance, I guess about a year ago. Then Chapter 42, just again a clarification there. There are a couple of sections that deal with roller skating on sidewalks and in city streets, and just feel like the section 42-14 should be deleted, and that particular topic dealt with in Chapter 74, which would basically prohibit someone from roller skating and using similar devices in the street to the point it impinges upon the normal flow of vehicular or pedestrian traffic. Amendment to Chapter 46 to deal with the typo, and then Chapter 50, which is the personnel and retirement section of the code, which houses the Winston-Salem Police Officers Retirement Plan. That's being amended because of federal law that basically in the IRS code defines marriage essentially as, or includes within that definition, same-sex marriages. So because of federal law, we have to amend our code to be consistent with that definition. So that change is codified, or will be codified in Chapter 50. And then Chapter 74, again, that relates to basically skating on the sidewalks and in the street, and then some other little changes, one of which would change the starting time for special events from 9 a.m. to 8 a.m. And that's to deal with the constant number of 5K races and runs that start at 8 instead of 9. And that's an overview.
Thank you. Move for approval.
Okay.
This is just for information.
Yes.
We were doing the 2 passes.
Okay.
So
All right.
Back in August.
All right. Save your.
Okay, I can save it. Bank it. I'll bank it.
Okay. C6, please.
Report on spacing requirements for electronic sweepstakes operations in the 25 largest municipalities in North Carolina.
Chris, you get to do the show.
Yeah, good afternoon, committee members. Included in your packet was a report at the December 2013 City Council member meeting whenever the electronic sweepstakes operation text amendment, the use was created, UDO 243. There were some, at least one citizen, maybe a couple, that asked us, or asked council to direct staff to investigate, analyze, and report back on spacing requirements for electronic sweepstakes operations around the state. And included in your packet is a report that looks at the 25 largest municipalities in the state of North Carolina. Of course, Winston-Salem being one of those 25. So looking at 24 other jurisdictions and setting forth how they, if they have specific uses regulating electronic sweepstakes operations, and if so, if they have spacing requirements and other use conditions that pertain to that use. Of the 25 that were looked at, the 25 largest, 10 jurisdictions do have regulations specifically pertaining to electronic sweepstakes operations. Of those 10, 9 of them have spacing requirements, and we, being the 10th, do not. It is interesting to note that most of the largest cities in North Carolina do not have any regulations related to electronic sweepstakes operations. I believe out of the top 10, I think there are 3 that have regulations, all smaller than Winston-Salem, Fayetteville, Greenville, and Wilmington. The spacing regulations, of course, I included the table there. They vary widely. They also vary. You'll have some that have a straight number, and that's between electronic sweepstakes operations and also other uses such as residential uses, churches, schools. You'll have some that have a certain spacing requirement set up between electronic sweepstakes operations and maybe have a smaller distance or in some cases a greater distance between electronic sweepstakes operations and other uses such as schools, residential uses, churches, etc. This was for information purpose to the committee. If the committee so desires, what we could do is go back and work with the city attorney's office and bring forth a possible text amendment for your consideration, and then obviously consideration for the full council. But obviously that's going to be your prerogative.
Are there any questions of Chris? I do have one on page 138.
Is it in the table?
Yeah, it's
Okay.
in the table. Yeah, it's Greenville. It says no electronic sweepstake operation may be located within a certified redevelopment area. I know we don't have that in our ordinance. Does anyone know if we do have I can't say that word, sweepstakes operations in some of our redevelopment?
Off the top of my head, I do not know because I am not 100% sure of where all the redevelopment areas
right.
are. If we do, there would be very few. If the committee decides to go forward with a text amendment to look at spacing, some of the things we'll have to look through is how we treat existing electronic sweepstakes operations and whether we're going to allow those to remain as non-conforming uses, non-conforming situations if they don't meet spacing requirements, or whether you would want to amortize those. So those are some of the details we'd have to look at, and that's one of the things that we could look at as part of any further analysis to look at our certified redevelopment areas and determine whether or not we have any in there currently.
Yeah, and it's also going to be difficult to sort out the separation things of existing operations, whether this one is half a mile from the next one or from a residential area or whatever. But I think it's worth looking into. Yeah.
I've got a question. I mean, it seems like the sweepstakes industry tends to be that whack-a-mole kind of thing where you come up with a regulation and they work their way around it. I'm wondering if that's going to be the same thing with these kind of distance regulations, whether they're going to be able to skirt it.
I'm sure they will try.
Yeah. Okay.
One thing I would ask is if the committee does desire us to go back and start working on a text amendment, maybe give us some guidelines as to what type of distances you would want us to investigate, whether you want us to have consistent distances, electronic sweepstakes operations one to another, and distances from those operations to other uses, what other uses you would like for us to consider. That's some guidance that we would probably need to go back and start working with the attorney's office to come up with some draft language.
You of all of us probably have more of an idea of what those sorts of distances mean.
I do, but I guess to me it would be interesting to go to some of these other municipalities to find out what has been the impact of placing a 500-foot or a 2,640 foot, whether it's really affected their operation. If not, I just don't see the point in doing it if it's not going to impact.
We can certainly make some phone calls and ask those questions.
Mr. Bessie.
If any of my colleagues want to explore it, I'm not going to object. My personal inclination is to think that once the amortization period runs, that most of the problem locations are going to be dealt with by that, and that we'll have fewer locations and fewer cases of problem siting for the facilities. But yeah,
I guess I wonder though. If we then, because we're cutting out places where these operations can be located, if then we're going to end up with 5 of them in one shopping center or whatever, without a spacing.
I think it's theoretically possible, but more likely they'd cannibalize each other's customer base.
Profit.
Yeah. Probably so. If we could check on what other cities have learned from this. That would be, I think, a good first step in seeing if we want to go ahead and get into the spacing question.
Check on the effectiveness with the ones that do have it, and just see if they've been successful, if they feel like it's cut down on any issues.
Yeah.
Okay.
All right. Thank you.
All right. Thank you.
Thanks, Mr. President.
Yeah.
Madam Chair, one more thing.
Sorry.
I'd be interested whenever you do come back to bring back the data so far as public safety is concerned. How many calls to that area? What have we found? What have we seen? Is it, do we get calls for breaking in cars? People know they're in there and they're like in there for hours. Any type of crime statistics or anything that you could get with public safety?
I'm looking at the city attorney on that one, because that was one of the things that we had kind of tried to get some information for when we brought UDO 243 forward back in December. So I'll defer the answer to that question to.
There's some challenges with trying to get that information, but we'll see what we can put together.
Okay, thank you.
Thank you both.
Thank you.
Thanks. Okay, I think we can move on to the general agenda and start with G1.
Information regarding AT&T Internet service sites as part of ultra-high-speed fiber network.
Hi, Dennis, please. Yes.
And good afternoon, Councilmember Light, members of the committee.
Good afternoon.
About 2 months ago, the city entered into a contract with AT&T to build out a ultra-high-speed fiber-based network across the city to serve both businesses and residents. Part of that agreement, there's commitment from AT&T to provide some benefits to the community. In particular, AT&T will provide 20-plus free high-speed network connections to community centers. They'll provide 20-plus build-out of physical connections to small and mid-sized businesses at no cost for the build-out, but the business will be responsible for any services they choose to purchase. And they will provide two multi-dwelling units or apartment complexes that meet the criteria of low-income housing. They will provide free standard rate, standard speed internet connections to all the residences of those multiple dwelling units. The discussion with council was decided that city staff would compile those locations to recommend for consideration by council. We would then bring those lists to council for your review and approval. Today, I'm here to bring this just to give you an opportunity, whether now or over the next couple of weeks, to determine if you'd like to make changes to those lists. We hope to have an item to council in August for final approval. The lists that you have were compiled with the help of, in the case of the small and mid-sized businesses, with the help of the Chamber of Commerce. As far as the community centers, we look to Winston-Net, an executive director who's familiar with all the various community centers that provide technology services to the citizens. And we worked through both the Community and Business Development Department of the city and ended up with final selection through the Housing Authority of Winston-Salem in selecting 2 MDU complexes. So with that, glad to answer any questions and take your direction.
Are there questions? Yes.
I just have one on the selection process for the small businesses. Who's got the criteria that were used? And some of these names in my ward are not companies that I know who may be very well deserving. I just don't know anything about them.
Frankly, it was the Chamber of Commerce, and what they attempt to do, we talked about guidelines and to find some distribution and just businesses that they felt were more on the need side and would meet the likely to be served from AT&T. And I should add that that list then was reviewed through the city's Department of Community Business Development, and there were some changes made to that list as well.
Is that?
I was just wondering, did we put this out for communication to the citizens in the Chronicle, the Journal, Facebook, whatever, all of the media that we use? Because there are small businesses, as you said, that aren't members of the chamber, and they may not be on certain lists with the Housing Authority or others because they're just small businesses and they're trying to make a go of it. I think we need to make sure, just like with nonprofits that come and ask our assistance, that the city as a whole has been communicated this asset and that everybody gets a fair chance to submit requests or whatever. And as to Councilmember McIntosh's comments, we need to make sure, we need to see the guidelines as to how these entities are going to be chosen, because it's got to be fair and it's got to be just and it's got to be consistent.
Sure.
Okay, thanks, Dennis.
Mr. Besson?
The only question I have would relate to the Old Vineyard Road area. I wondered if there was any effort made to identify a possible location there. In thinking about my district, that is probably the area of likely the largest number of modest income households, a lot of apartment complexes in that area that doesn't have a site within an easy distance.
Okay.
I didn't see any housing authority sites on the list. I can think of the Healy Towers is located on Old Vineyard.
A little bit more information about the apartment complexes. It was actually very difficult to find apartment complexes that did not already are not already bound contractually to our other major cable provider in the community that could be candidates for this. We had a long list, and almost every one of them, except for the two we proposed, are under long-term contract.
I'd like to ask that you take a look at Healy Towers.
Certainly.
Thank you.
And tell me, you said something, and perhaps I misunderstood, that the service would be built to these small businesses or whatever the area, and then the businesses would have to buy into the service?
They wouldn't have to.
Oh.
Typically, the cost to build, if you for a business to have this service, would be anywhere $500 to a couple $1,000, depending on distance and complexity, to build into their business. And AT&T will go ahead and pre-build that based on the locations we recommend. And there's no obligation to the businesses to purchase services, but it will be there in case they want to.
Do we have a sense that this is all we can get from AT&T in terms of numbers?
Yes, actually, this comes from the larger agreement between AT&T and NC Engine, North Carolina Next Generation Network. And the numbers, for example, the city's participation of 20 comes from a total of 100, which were then divvied out between the 6 municipalities based on population.
Okay, all right, there's, okay, we have information that's been requested. So if we could get that, and then you will be back next month.
Yes. And just to add a little bit more about the process, AT&T is asking us to provide this list to them as soon as possible, but there's not a hard deadline. It says 120 days in the contract. The reason they like to get it as soon as possible is they're doing their design and engineering, and if they're aware of where we would like them to make connections, it could make a difference.
Mm-hmm.
And so,
But there is adequate time for
Yes,
us to
yes.
have a month for
Correct.
more information.
there is.
Okay, thanks, Dennis. All right. G2, please.
Report on compassionate cities.
Jerry. Yep, sure. If you all will give your names and addresses, please. Welcome.
My name is Jerry McLeese, 851 West 4th Street, Unit 23, 27101. We're here tonight to thank the council for an action it took a year ago tonight, on July the 15th. That action was to unanimously approve or endorse the Charter for Compassion. We would like to thank first Mayor Joines, who gave us the go-ahead to look into this, to bring it to you. We'd like to thank Chairwoman Light for sponsoring the resolution, and Chairperson, at that time, Bessie, for guiding us, shepherding us through the process. All of you have been very helpful to us in getting us to where we have come. Winston-Salem became the 18th city in the world to endorse the Charter for Compassion. There are now over 200 cities trying to get to where we are right now. Among those who have endorsed the Charter since Winston-Salem did are Atlanta and St. Augustine, Florida. So we got in ahead of them, and so it's always nice to have that notch in our belt. At the beginning of this effort, the Board of Interfaith Winston-Salem saw the potential. When the council saw the potential and gave an endorsement for it, it added legitimacy to what we were doing. And since that has happened, we have seen our activities grow organically. Just yesterday, a lady who is in this room met with me. She came here 2 weeks ago from the state of Washington, found out some of the things that were happening with Compassion at Winston-Salem, and has immediately gotten involved with that because she is excited to see the kinds of things this community is doing. Not just what we're doing, but that are being done broadly, because we have seen people step forward without any encouragement from us, but with the leadership that the council has provided. And they themselves are doing things like, as simple as buying a cup of coffee for the person behind them in line. Little things like that can make a difference in the community. Right now, our organization is focusing on about 5 or 6 different areas in compassion. We'll have some news about what we're doing with elementary schools coming up very soon. Dean Clifford, whom many of you know, is involved in that effort. We're starting to do some things in workplace compassion. We through Interfaith Winston-Salem, are doing interfaith compassion activities. We have a number of animal organizations that are working together to provide a compassionate approach in that area. And we're also starting to talk with the healthcare industry about things that we can do to provide a more compassionate healthcare arena. Drea Parker, who is my colleague and has been working closely on this, can tell you some of the things that are going to be coming up over the next few months and the next year.
Thanks, Jim.
Hi, my name is Drea Parker, and I live at 332 Gloria Avenue, 27127. And I echo Jerry's thank you very much for endorsing the Charter for Compassion. As he mentioned, we have several groups in the works that we have established with the education, the K through 12. What he highlighted is that we've got a compassion corner that we are in the process of getting established in area schools here in our system. Truman Dunn and Dean Clifford are spearheading this project to have these benches installed in the playgrounds. And more Magnet Elementary School is going to be our pilot school, and Bolton Elementary will be our second, and we're looking to have these implemented, or at least installed, before school starts, but then we're going to have a celebratory exercise in October, of which we will have created compassionate exercises and compassionate training to teach the kids that when they see someone sitting on the bench, it's an effort to go and give them an act of kindness. and it will highlight and teach children that an act of kindness can go a long way. As you see, the image here is in your packet. Also, Truman Dunn is also working with Wake Forest University to establish an internship to focus on compassionate programs that the local businesses already currently have in place. We're hoping to have this established and set for the 2014-15 school year. And with Christine Trethway and myself, we are working with area and local animal rescue groups to bridge the gap between the service organizations. And one of the things that we have upcoming is a live blog to focus and show all the acts of compassion that are shown to animals in our community, and helping to teach people how to be a more responsible pet owner. And we will be participating with local festivals, helping to raise awareness of compassion, and that how when we bridge the gap and connect with one another, we can create a more harmonious community. And we'll be at Elite Canine's annual Canine Challenge in September. And then in October, we'll be at Link Up again. We were there for Rachel's Challenge, the anti-bullying campaign, and helping to distribute material and asking people to sign the charter and participate in being a compassionate community, as well as being involved with Pride Winston-Salem, the local LGBT community. And we are expecting to receive a grant from Adam Foundation to help with the benches, as well as from other local, Norwood Baptist Church and the Temple. At Temple Emmanuel will be helping to support and raise funds for the benches for the Compassion Corner. To add on to the social justice program that we're working on in collaboration with HRC, you'll also find enclosed with your handouts is a list of accomplishments that the Human Relations Commission has achieved and experienced in the last year, namely to focus on that they received a National Cultural Diversity Award from the National League of Cities in March, as well as the UNC Chapel Hill Building Integrated Communities In-Kind Award. So these are just a few of the things that we've done in the last year and what we're planning to do in the next 6 months, and we're looking forward to coming back next year on our anniversary to once again thank you and to share with you what we've done since then. Thank you.
Thank you.
Are there any comments or questions? Mr. Bessie.
I just had a quick question. I was looking at the Human Relations Commission's plan of action and trying to understand whether this was a summary of what you have done over the past 12 months or a summary of what your plans are for the next 12 months.
I do believe it's a summary of what they have done in the past 12 months. And we're reporting what we've done to date and then what we're hoping to do in the next.
So this is what you have done.
Mm-hmm.
Okay.
Yes. Is that what we've done?
Now and going into
Do you want to add some what you've done?
Good afternoon.
Good afternoon.
To answer your question, Councilmember Bessie, it is a reflection of what we have done, but these are also continuing programs that we pretty much do year-round. And so we always update this list. This list was good for fiscal year 13-14, but we do constantly look for other things that we can incorporate, including our own new programs that we may create in the meantime.
Yeah. So it didn't have any years.
Okay.
Beside the months, and so and most of it was stuff that is recurring. That's
right.
Why I wasn't clear.
Exactly.
Thank you.
Sure.
Anyone else? Thank you all so much for what you're doing.
Thank you.
Thank you again.
Very admirable. G3.
Discussion of city policy extending same-sex domestic partner benefits.
I think, Ms. Carmen, this is yours.
It is. What you have before you for discussion purposes is a draft resolution that would extend, if adopted, certain benefits to same-sex domestic partners based upon criteria that is consistent with dependent status as found in GS 160A 162B, which essentially allows the city to provide certain benefits to employees and dependents. And it's also consistent with similar policies from other cities, including the policy that became effective on January 1st, 2013 from Charlotte. You'll see basically, for the most part, it's almost word for word from the Charlotte policy. And I'll talk about the benefits that the draft policy would extend to same-sex domestic partners. Those benefits are listed on page 15 of the draft resolution. The benefits include medical and dental coverage, vision, long-term care, and employee assistance. It also includes sick leave, family medical leave, accident and sickness leave, and funeral leave. And for pension purposes, basically it would extend the right of survivorship benefits under the pension plan to domestic partners, same-sex domestic partners. And for purposes of 401k and 457 beneficiaries, it would also include within that definition dependents who are same-sex domestic partners as well. Based upon the criteria listed on page 15, we would look for, or the city would look for certain things to establish that the same-sex domestic partner is in fact a dependent. There are a list of about 12 plus some subcategories. I'll just mention a few just as highlights. Basically, the same-sex domestic partner would have to establish, and it would be through an affidavit, a few things such as, number one, that they are of the same sex and not legally married or in a civil union licensed under state law with a person other than the two signing the affidavit. Essentially, what that's trying to avoid is the situation where a person has actually gone to another state where same-sex persons can marry, and they're married in that other state, and then they come here and try to establish a different person as their same-sex domestic partner, while they're married in another state to a different person. So two people who are actually signing the affidavit would be the persons who are involved in the same-sex domestic partner relationship. Gotcha. Another one, number 4, that they are jointly responsible for each other's common welfare and share financial obligations. Number 7, consider themselves to be members of each other's family, immediate family. And 8, are responsible for each other's basic living expenses. Again, the objective here is because it's clear municipalities have the authority to extend benefits to employees and their dependents. What the objective of this approach is to basically establish the same-sex domestic partner as a dependent consistent with the statute. And those are some of the highlights, and I'll be happy to answer any questions.
Mr. Best? No?
Oh.
This is for discussion, right? We're not.
It's for discussion.
Yeah.
I'll bring it back in August.
Yeah.
Okay.
Yeah, I would like to just say that I'm very pleased to see this before us. I mean, I think it's very, it's important for us as a community to treat people fairly. In my business day-to-day, I deal with fair housing laws, and lack of discrimination there is just sort of ingrained into me. So I'm really happy to see this come before us, and I know we've got some differences of opinion on how to proceed, but I don't think anybody, at least I haven't heard from anybody yet, who thinks that we should not proceed. So I'm looking forward to this, one way or the other, becoming part of our community.
Yes, ma'am.
Thank you, Madam Chair. Thank you, Attorney Carmen, for crafting this draft document for us. I would be interested to see when you bring it back, do a side-by-side matrix comparison with the other cities in the state that are doing this, and then, the normal, just put us in there as to what we're trying to do here. But I agree with Councilmember McIntosh, and I'm sure the rest of us. I always like to say Winston is unique, just like all of the other urban cores in the state. We are a great state, but the urban cores don't reflect sometimes the views of the state. We believe in what's just and right, and we all believe in what's consistent, because what Charlotte, Chapel Hill, Raleigh, Durham, Wilmington, Asheville, Greensboro, whatever they do, we will do normally too, and whatever we do if we're the groundbreaker, they will follow suit as well, whether it was with the sweepstakes or whatever. So I'm glad to be a citizen of Winston-Salem today.
Yeah, I'd like to add my appreciation to Attorney Carmen for a creditable, first draft. I do have some specific points of dissatisfaction with the draft as presented, and I actually have an alternative. But before I go into that, I wonder if we were going to invite comments from
Yes, we
from the
certainly
audience.
can do that. We have plenty of time. So are there people in the audience who would like to speak? Come ahead and give us your name and address.
Hi, thank you. My name is Brett Hodges Morin. I reside at 3000 Pinecrest Drive in the South Ward. My husband and I live together. We've been together for 10 years now. We were married in D.C. So I have a couple points to make on this proposal. I currently work for a private nonprofit here in Winston-Salem, and we recently enacted same-sex equivalency benefits. So my first point that I'd like to urge the council to consider is the point of the affidavit. I recently filled one of these out, and my husband and I were married in D.C. and could provide a legal marriage certificate from the District of Columbia. However, we still had to make certain points to meet this affidavit. I would urge you to consider a legal marriage document from outside of North Carolina to count as satisfying the requirement to meet. Then it's the same thing that any other heterosexual couple would be providing a marriage document to suffice. Also, I'm the Vice President of Pride Winston-Salem, and I'm here representing also Pride Winston-Salem and thanking the council for taking this on and seeing that we are meeting the standard that I hold to my city. I've been a resident here for all of my life. My father just retired from the city of Winston-Salem. My mother's about to retire from Forsyth County. And she said to me off the record, even though I know this is on the record, she retires in December. And she's been there for 30-some years plus. And this is her charge to the county government that she'd like to take on when she retires. And I'm really proud of my mother for that. And so I'd like to see Forsyth County follow suit, follow your lead. So I wanted to make that point. And finally, if you look at some of our largest employers, Wake Forest Renalda campus has been offering domestic partner benefits since around 2000. Sometime after that, Novant Health started offering domestic partner benefits. And I was a former employee of Wake Forest Baptist Medical Center. And one of the cited reasons for their picking up domestic partner benefits in 2013 was, in addition to equitable treatment of their employees, was for retention efforts and recruitment efforts for their employees. They had to compete with Novant, and I think that's important to note. And finally, when our company, Carolina Donor Services, we're the organ and tissue organization for the state of North Carolina, offered domestic partner benefits, I was immensely surprised by the number of my straight employees that were very proud to speak out and say how happy they were that their employer was now offering this. Did not impact them one bit, but it mattered to them. It mattered that they worked for an employer that offered these benefits to their colleagues. So thank you again.
Thank you. Is there anyone else who would like to speak? Please come ahead.
Hi, my name is Liz Venom. I live at 640 Anson Street. I think the city of Winston-Salem is, like the councilwoman said, a leader, and we demonstrated that when we passed the non-discrimination policy. But if you look at the way city employees live their lives, they're still being discriminated against because they have to pay so much more. I've worked with city employees who have to pay out of pocket for their spouse and for their children. So even though on paper we say we're not discriminating, it ends up being a discriminatory practice. So I think this policy is great. I do encourage Councilman Bessie's changes. I think those are a good idea. And I also agree with what Bryn said about being competitive. We want to be able to compete for the best and brightest and a really diverse workforce. So I think this is a great measure, and I look forward to hearing and seeing it pass. Thank you.
Thank you. Do I see anyone else who would like to address the committee? Okay, all right. Ms. Carmen, tell me the argument, see if you can get it into my thick head, about not using marriage certificate from another state as the basis for this, for this.
Sure, I'll be happy to. Again, you look at the enabling legislation for the provision of benefits to employees, and that legislation in 160A, 162B talks about employees and their dependents. And while we can define dependents, we really need to focus on truly establishing that dependency status. So you have that provision. Then, of course, you have Amendment 1. And experts who've looked at Amendment 1 have basically opined that a local government cannot enact ordinance resolution that would recognize the legal status of a marriage between same-sex partners that was conducted in another state. So you have that challenge to Amendment 1, and then you have to look at what you're authorized to do. So if you look at dependent and trying to establish dependent status, simply relying upon a marriage certificate between same-sex domestic partners from another state in and of itself does not establish dependency. And I understand in terms of spouses, a marriage between a man and woman, that allows you to become a dependent of an employee. In other words, my husband would be a dependent under normal circumstances. But that is in part because you don't have a constitutional amendment that says that our marriage is basically cannot be recognized. Our marriage is recognized. But when you try to establish a dependent based upon a marriage from another state, which this state does not recognize, then you are arguably not doing something consistent with 160A, 162. You really need to look at establishing dependence based upon a dependent status, not just simply a marriage certificate from another state, in particular a marriage certificate that's not recognized here. And I know that's a lot, and I'll be happy to answer any questions. So what we need to focus on is trying to establish dependence based upon 160A, 162B.
Okay, because we could get in trouble with the state if we went against their Amendment 1.
There is that argument because, again, legal authorities with respect to what Amendment 1 means have opined that Amendment 1 means, now we're talking about local government, we're not talking about the private sector, but between states and local government, as it relates to local governments, we cannot do anything that recognizes a marriage between same-sex individuals from another state. And having a resolution that in essence does that would arguably be in violation of Amendment 1. That's why I focus solely on 160A, 162, which allows us to extend benefits to employees and dependents. And so I try to focus on what is a dependent. Yeah. And while, again, marriage between man and woman, you don't necessarily have to establish dependency, there are other categories where you do have to establish dependent status. For example, with respect to children. If my husband and I were divorced, and there was a question as to whether or not my kids were my dependent versus his, we'd have to produce some documentation showing that they're my dependents, because I'm the employee and I want to claim them as far as insurance purposes. So there would be some documentation that I would have to submit to establish that. So again, based upon the statute that gives us the authority, the city, to provide benefits to employees and their dependents, I try to focus on establishing dependency or dependent status, not looking at marriage or recognizing a marriage from another state. This is focused on dependence. Does that make sense?
Yes, thank you. And the next question, of course, would be if, in fact, we as a city recognize same-sex dependent partnership, then do we also extend that same recognition to opposite sex?
Okay, it is a policy choice, and I'll try to be clear and concise on this point. Based upon case law, the council very well could decide to extend benefits to same-sex domestic partners and not opposite-sex domestic partners. Because in the case of same-sex domestic partners, there is a law here in North Carolina that prohibits them from getting married, whereas opposite-sex domestic partners are not legally prohibited from getting married. So there would be a rational basis for extending benefits to same-sex domestic partners based upon dependent status and not opposite-sex domestic partners. That is a choice. You could very well decide to, again, using 160A, 162B, to extend benefits to opposite-sex domestic partners based upon dependent status.
Okay, thank you.
Does that make sense?
Yes,
Okay.
thank you. Yes.
Yeah, this is very helpful and illuminative of some of the problems and choices. And I'd reiterate that I think our attorney has done a creditable job of bringing forward an alternative based on what some cities in North Carolina have done over the past several years. And if you look at the historical circumstances, when other cities like Charlotte and ones that preceded Charlotte started making an attempt to move toward fairness for same-sex couples and partners, that this kind of policy that we have drafted in our packet today was a step forward at the time. I think today we can do better because the policy as drafted, as modeled on what some other cities have done over the past few years, continues to fall short of truly fair and equal treatment for all our citizens. It sets up, in fact, an odd, double discrimination. On the one hand, it does not recognize the legally contracted partnerships that many of our citizens have already established under the laws of other states. And so it's continuing a level of discrimination against those same-sex couples that we don't have to continue. And on the other hand, by excluding opposite-sex couples who would otherwise meet every other eligibility criteria here simply on the basis of their opposite-sex partnership status, it excludes from equal benefits a lot of straight couples. So in effect, it's a Class B kind of approach. You can argue that it's a step forward. I would suggest it's not good enough and not all that we can do at this point. And the discussion of the potential argument under North Carolina state law that would preclude doing more or doing an alternative approach that included some form of acknowledgement of a same-gender legal marriage or union in another state is a good illumination of the kind of argument that could be brought forward. However, I'm not personally satisfied with relying on that. I think there comes a point at which fear of being sued interferes with our duty to provide fair treatment for all our citizens. And I think we have reached that point here. There are now 19 states in the District of Columbia, covering more than 40% of the American population, which recognize some form of same-sex marriage or civil union. Courts in 9 other states have struck down bans on same-sex unions as contrary to the equal protection guarantees of the U.S. Constitution. And the only reason those 9 other states are not included in that 20 jurisdiction total is that those rulings have been temporarily stayed pending appeal. But this is a dynamic area of the law. It's shifting very quickly now and has shifted already enormously in the few years since other cities in North Carolina adopted the sort of the Class B approach that we have before us as an alternative. Increasing numbers of our Winston-Salem citizens may come from states which recognize these unions, or even, in some cases, Winston-Salem residents and citizens who have traveled to other states to take advantage of the opportunity to legally marry there and have returned home to Winston-Salem. I believe that it's possible to interpret the recent Amendment 1 to the North Carolina Constitution in a manner that does not prohibit Winston-Salem and other local governments from taking note of these legally binding contractual relationships as sufficient showing of a family-dependent status to establish eligibility for coverage under our personnel benefits policies. Some people can make an argument that it does. I think we can make an argument that it does not prohibit. And more importantly, candidly, it seems clear to me that any interpretation of Amendment 1, which did require us to ignore those legal contracts, would be struck down in court on challenge as contrary to the full faith and credit clause of Article 4 of the United States Constitution. It's pretty straightforward. U.S. Constitution trumps anything to the contrary in the state constitution. Based on those factors, I believe it's time for us to do the right thing and explicitly incorporate a provision into our personnel policies that treats any marriage or civil union legally formalized in another state as sufficient showing of a family-dependent status to establish eligibility for coverage under our personnel benefits policies. And I'd move that we ask our attorney to draft language to that effect and bring that back to us to consider side by side with other alternatives at our August meeting.
That is in the form of a motion.
Second.
Any discussion of that? Oh, Mary, yes. Come up.
Sorry. I wasn't planning on speaking, but as the conversation has evolved, my name is Mary James. I live at 203 Admiral Way in Moxville, and I work and have a business in Winston-Salem. First of all, thank you so much for this conversation, and I appreciate all your support, that consistent support throughout the years for the work that you do, especially around LGBT issues. I want to bring up an interesting point because I think, to your point, Councilman Bessie, my partner and I recently filed our state taxes together. We were married in December in New York City. We filed our federal taxes, as was legal, but we also challenged the state and filed our state taxes, married filing jointly this year. And we challenged the system. We sent our taxes certified mail to the state. We sent a copy of our marriage license and a photo of our marriage so that we could draw attention to the fact that we were doing this, and we wanted to be recognized. We received our refund about 2 months later with no questions asked. So I think to the point that you're making, the state is not challenging us in how we filed our return, and I think that's an important point to make as we really choose not to write discrimination into these laws, and I appreciate the city attorney's efforts on behalf of this, but I think you're right. I think we can push this issue a little bit, and what you'll find is that the state is not prepared to challenge this, as we found, and as other couples have found, as it relates to LGBT rights. So, again, thank you. One other thing I would ask for you all to think about, I didn't see COBRA benefits in that proposal, and I didn't know if that was going to be addressed as well. So, again, thank you.
Thanks, Mary.
I wanted to make a few additional points. Just in terms of Amendment 1, I think I agree with a number of legal scholars that at some point Amendment 1 will fail. there are at least 2, maybe 3 cases, I think in total 3 cases in North Carolina challenging basically Amendment 1. There is a case in the Fourth Circuit out of Virginia basically challenging a similar law, a similar ban on same-sex marriages. So I think it's inevitable that it will fail. And certainly council at that point in time, if it wants to come back and change its resolution, it could certainly do so. I just wanted to point that out. But in terms of COBRA benefits, at this point in time, it's not included. Certainly if that's what you want to include, I can look at including that.
A question for, are any of those challenges being made by municipalities?
No, they're not to my knowledge.
And then wanted to ask also about Committee Member Bessie's point about the legally contracted, and how has that been challenged before? Is that pretty much set precedent? That I mean, it seems like to me like that's a pretty strong argument.
I am not aware of any specific precedent applying the full faith and credit clause to a state's refusal to recognize a marriage contract that was legally binding in another state in this context. But I have not done the research to determine whether there are cases out there that have employed that. My general impression, well, if somebody's raising their hand, they may actually have more current information than I do on that point.
Yeah, if someone would like to clarify that.
Sorry, yes, the full faith and credit clause doesn't apply to marriages because marriages aren't in order. It only applies to court orders. So adoptions, yes, other things, but not marriages. So when all these lawsuits have been brought in other states, they don't sue under the full faith and credit clause. They sue under equal protection.
It's usually the 14th Amendment, because under the Windsor case dealing with the Defense of Marriage Act, that was the 5th Amendment, and the due process, the denial of due process, that was the basis for that challenge. So for state laws, it would be the 14th Amendment.
And my impression was that most of the challenges have been brought under equal protection rationales as well. I suggest full faith and credit as an alternate or an additional argument, but I'm not
aware.
Not a practicing constitutional scholar. So
fool me.
It's usually the 5th Amendment.
Maybe you can say I play one on TV, but the argument that Wood put forward is that I think that any interpretation of North Carolina Amendment 1 that precluded us from taking into account what's going on in other state would fail on constitutional grounds.
Yes.
Thank you. Attorney Carmen, where does the league stand on this as well? Or, not that we have to have any one to go with us into battle, we can handle our own, but what do you think about the league in other states that, as Councilmember Bessie say, have basically done the Class B side of this, and the way it's changing and evolving every day? Do you think anybody else would come with us in this fight? Think about it.
Let me do some
Just think about it.
research.
I know you got some friends. Think about it.
I have an answer, but I'd rather provide it in a different form.
Very good.
Well, and then there are other challenges, as indicated, that could be partners. Yes.
One thing I wanted to add to my answer a minute ago, part of what made me think in terms of the full faith and credit concept is that I do know that North Carolina does recognize marriages established in other states, even if they weren't fully up to our rules in many cases, and of what you would have to show to us to get married in North Carolina. And I would think of this as an extension of that.
Marriages opposite sex?
Yeah.
Right.
I know it's impossible to really get a good number for, but what would a challenge cost us?
It's hard to say. It's hard to say, and
7 figures?
At least 6. I was going to respond to the question earlier, which I kind of deferred on. I do know that other municipalities are kind of waiting and looking at the court cases that I just mentioned to you. So I don't know to what extent they would help and maybe contribute to the cost, but it's certainly.
One other note, I mean, Councilmember McIntosh certainly raises a valid question. I would suggest at this point for those who are trying to enforce a provision of the North Carolina Constitution that's destined to fail, it's currently a target-rich environment for them, and they'd really have to decide to single us out in a battlefield where they're losing on other fronts already. So
Yeah.
The only thing I would say, I guess, is that, again, hopefully I make this clear, you have a statute that talks about providing employees independent benefits, and so if it's, one could argue that a policy that goes beyond that, the city has exceeded its authority. So that would be an additional legal basis for challenging the city. And the outcome, if that plaintiff were successful in terms of attorney's fees and so forth, that might be something that the city would have to look at, not only its attorney's fees, but the other side.
Can I clarify? I think what I heard Councilman Bessie saying was that the first approach that he was looking for, though, was to try to stay within the statute to some degree by saying that if a couple can demonstrate that they've been married in any state, that would be sufficient showing for dependent status, which the law allows us to do. So I think we try to write it that way.
And that was specifically what I was asking for in order to stay
Right.
within
We had that discussion, but again, that takes on the flavor of recognizing a marriage from another state.
And I concede that you can make that argument with a straight face in court, and somebody might well do that. And I go back to sort of my opening comment, that there comes a point in which fear of being sued interferes with our doing the right thing for all our citizens, and I think that is the point we've reached here.
And I certainly agree with you on that. I think fear of Raleigh has hampered us in other ways, and maybe we ought to quit letting it happen. So, okay, all right.
Got to take a stand.
So, Ms. Carmen, you're going to bring us back something that incorporates the language of recognizing a marriage license from another state between same-sex couples as proof of a dependent status.
I will. I have one additional question. Now, I have not done a survey of our employees and certainly don't anticipate doing such. But I suppose that we have employees who have a same-sex domestic partner who have not taken the step of going to another state to get married. So what do you want to do with respect to employees who do have a same-sex domestic partner but have not taken that initial step? Are we going to say...
Well, then you do the affidavit that incorporates all of these dependency proofs.
Can we combine them?
Yeah, both.
And I would say that I would not oppose that as an alternative as long as it's applicable to both same-sex, opposite-sex couples.
Yeah.
To be fair.
Yeah.
Yeah. Basically, that in our policy as it is, recognizes the North Carolina marriage as evidence of that dependent family status. I'm proposing an alternative that would, take as evidence of the family dependent status marriages that have been legally entered in other states as well. So you even the playing field there as much as we can for partnerships, both same-sex and opposite-sex. If we are going to set up an additional route that would permit establishing that evidence of a family dependent status through sort of separate set of tests, then again, let's be fair as much as we can and say you can bring forward that evidence if you're in either a same-sex or an opposite-sex partnership.
Okay. tell me, I've lost the number now, how long a duration?
12 months.
12 months? So I could change boyfriends every 12 months.
You could,
If you meet the other test.
if you can find them.
There are other
benefit
tests you would
analysis on
have to meet, Councilmember Light.
Cost-benefit analysis.
Oh, okay. All right, then. Are there any other comments or requests of the attorney? No? All right. Thank you, and we'll continue this next month, I guess, or whenever it comes back.
Shoot for August, but it might be September.
Okay, all right, very good, thank you. Anything else from the committee? We're adjourned.